with his attorneys, Mr. King. I don't see Ms. Brady, but
She's just outside.
she's outside, okay. Ms. Higgs is here, Ms. Spengler and Ms. Nelson are also here, and then on behalf of the people, we have Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Edson, and Ms. Stitch McGuire. We are outside the presence of the jury. Yesterday there was a bench conference that I had. Actually, there were a couple of bench conferences related to the defendant's statements, and these were the statements related to August 2nd and August 4th, I believe, of 2012, while he was at the jail. I know one of them was with Mr. Edson. I can't remember who the other one was with, but Ms. Higgs, I think, was involved in at least one of them, and perhaps both. And the objection was as to hearsay, and the people argued that the statements were being introduced for the truth of the matter asserted. These were statements that had to do with apparently the defendant using a spoon, I believe it was, to try to see what was behind an electrical outlet. And then the other one had to do with some kind of hair gel bottle, is that right? And a light bulb. And I thought more about it last night, and I agree with the people that both are being introduced for the truth of the matter asserted, or were being introduced, I should say, for the truth of the matter asserted. In both cases, the statements are being introduced exactly for the truth of the content of the statement. That is to say, the defense was showing that this was the defendant's intent, that his intent was to see what was behind the electrical outlet, and in the other case, that his intent was to do something with the light bulb and this hair gel bottle. The defense wants to rely on that, I understand, to argue that this is evidence that the defendant was insane at the time of the commission of the act, but they were being introduced for their truth. Ms. Higgs, I think, argued a couple of exceptions, and I'm not sure whether she argued both with respect to both statements or not, but I know that she argued a couple of exceptions with respect to at least one of these statements. One exception was present sense impression, which is 803 subsection 1, and the other one was state of mind under, I believe it's 803.3. Let me just double check. Yes, 803.3. And I think she was right. I think under 803.3, these fall within the exception to the state of mind exception of the hearsay rule, because in both cases, the statements are about the defendant's intent or plan. He was asked a question about why he was doing what he was doing, apparently, or what he was doing, and then he stated what his intent was or what his plan was. In one case, because apparently he was trying to find out what was behind the electrical outlet. In the other case, because actually I don't know what the purpose was in the other case, because I don't think that came out, at least not yesterday. And both of these statements actually may have come out already with experts. I know that there have been some questions along the lines of these two incidents or related to these two incidents, and I can't remember whether the statements actually came out or not, and I can't remember at which point in the trial they came out. Obviously, this is a lengthy trial, but I seem to recall both of these incidents being alluded to in the past, It may have been by the prosecution and it may have been by the defense, but regardless, I sustain the objections and I'm reversing those rulings. So I will let the defense introduce both of those statements if the defense wishes, either by recalling the same witness or by calling a different witness or through documentary evidence such as a jail log or through an expert or however else the defense wants to do it. But as I thought about it more and as I looked into the case law, I decided that Ms. Hicks was right, and I'm relying on People versus Glover, which I have cited in this trial multiple times, but it's cited at 2015 Westlaw. I believe it's 7953690, and it's specifically footnote 5 in that case. And then People versus Acosta, which is cited at 338 Pacific 3rd 472. That's a Colorado Court of Appeals case from 2014. All right, and I think those were the only two statements that I remember that I excluded yesterday. And what got me thinking about it more was a bench conference that we had toward the end of the day when we were talking about statements that the defendant made, I think, during a different incident. I think it was during the November 2012 incident. And those statements came in. I admitted those statements, but I had excluded the two statements that I just referenced a moment ago. If there are any others that I excluded that I'm not remembering, I'll leave it to the defense to remind me and to let me know. But I believe those were the two that I excluded, at least as far as I'm remembering right now. Ms. Higgs had asked me to reserve ruling on the video recording that was taken at the hospital. And I don't know that these DVDs have been marked yet. Have these been marked as exhibits yet, Ms. Higgs?
No, sir, I don't believe they have.
All right. Do you want to talk about them now? I think you had asked me to allow you overnight to think about the people's hearsay objection.
Yes, please.
And just so that the record is clear, this is a video recording that appears to have been taken by an investigator from the public defender's office while the defendant is in the hospital. Is that right?
Yes, it is while he is in the hospital on November 19th of 2012.
Okay.
November 19th or 20th.
All right. And the objection that I think you wanted to wait to respond to was the hearsay objection.
Yes.
And I've had a chance to review the videotape. I reviewed only one copy of it. I reviewed the one that has the subheadings, but I did review it last night.
Thank you, Your Honor. And one of the things that I think the court mentioned yesterday was, or asked yesterday, was whether at least portion of that video was played during opening statement. And it was. I went back and reviewed that clip that was played, and for ease of discussion, Your Honor, I have a transcript of the entire video, so I can point to the court on the transcript the portions that were actually played during opening statement. I'm happy to approach with a copy of that.
Is it an official transcript or is it an unofficial transcript?
It's a certified transcript by our office. Okay. With a certificate.
All right.
And I have a copy for the people as well.
Great. Thank you. Thank you. Is this this is the transcript of the excerpt that was played?
This is a transcript of the entire video. It mirrors the subtitles that the court viewed on the video, but just for clarity of the record, I thought it important to be able to point out where on the transcript the clip from opening statement began, and that was on page 2, line 42, and it went through page 6, line 47, or line 37. I think that that's clearer for the court than pointing out the times on the video of the clip that was played. And I would note for the court, Your Honor, that the people had all of our opening exhibits prior to opening statement and made no objection to Mr. King playing that clip for the jury during opening statement. Also initially, Your Honor, I will sort of let the court know what this information is being offered for, and I think there are two two sort of, I guess, exceptions to the hearsay rule, although the first really isn't an exception to the hearsay rule. It's just that it's not hearsay, it's not offered for the truth, but to show mental state and mental health. For example, when Mr. Holmes is talking about seeing shadows and what the shadows are doing, it's not for the truth that there actually are shadows present, but rather for his state of mind. And it's to rebut the prosecution's claim and their suggestions that he has been exaggerating or inconsistent, not really mentally ill, and their implications that he is sort of making this up. I would also offer these statements under Colorado Rule of Evidence 8033. I mean, the court just referred to that exception to the hearsay rule, and it does include statements of mental feeling, pain, bodily health, all as part of that exception to the hearsay rule, and we believe that these statements do fall under that exception. The other issue that I'd like to make a record about is what the DA has done in their case, because this is to give the jury a full and fair understanding of Mr. Holmes' mental state at a particularly vulnerable and important time, which was directly after his psychotic break in November of 2012. I mean, the DA has cross-examined repeatedly about how it's important to have videotape. I would think that they would welcome additional actual videotape statements of the defendant to show, of Mr. Holmes, to show his demeanor, to show his state of mind, to shed light on his mental illness, and that is one of the things that this video does. It's relevant for the jury to see his demeanor just a few days after beginning antipsychotic medications. I think this is especially relevant in light of the 22 hours of video the prosecution was allowed to show over our objection, which all occurred with Dr. Reed years after he was on the antipsychotic medication. And in light of some of the doctors from Denver Health that talked about the effects of the antipsychotic medication sort of taking effect immediately, but the full effect would not be seen over time. And so this video of him just a few days after beginning the antipsychotic medication gives context and a jury a full picture of how the antipsychotic medications are beginning to take effect but haven't reached that full effect that we see in the video with Dr. Reed years later. I would note that the prosecution has been allowed to introduce a number of videotapes of Mr. Holmes, aside from the videotape with Dr. Reed, which includes various stores that he went to prior to July 20th of 2012. It includes video with audio of his last lab presentation in May. It includes video and audio of his statements to police directly after his arrest on July 20th. They've also been allowed to introduce a number of statements of Mr. Holmes through the forms of emails, statements to teachers, statements to friends. They've introduced statements of Mr. Holmes through kites in the jail that include library requests, medical requests. Through all of this and throughout their cross-examination, particularly I would note of Dr. Woodcock, they've argued and implied that all this shows that he was sane, but not only that, but that he wasn't even mentally ill. They've implied that he's not even significantly mentally ill to this date. And this information is particularly relevant to rebut those assertions and insinuations. The prosecution has called into question Mr. Holmes' credibility, especially about discussing hallucinations with various doctors. I think this goes to rebut part of those allegations. It's fundamentally unfair to allow the prosecution sort of this open door to admit anything and everything they want to with regard to things that Mr. Holmes said without allowing Mr. Holmes to put that in context and give the jury a full picture of what his mental health and mental state is like throughout all of these relevant periods of time. I think it also in particular gives context to Dr. Holland's testimony. If you will recall, he talked about Mr. Holmes sort of covering up with the sheets, and this is further context to that testimony. I will make all of my arguments under Mr. Holmes' right to fair trial and fundamental fairness under the 6th Amendment of the United States Constitution, Article 2, Section 16 of the Colorado Constitution, under Mr. Holmes' right to due process under the 5th and 14th Amendments of the United States Constitution, Constitution, Article 2, Section 25 of the Colorado Constitution, Mr. Holmes' right to a fair and reliable sentencing hearing under the 8th Amendment to the United States Constitution, Article 2, Section 20 of the Colorado Constitution. I'd also argue it is relevant under Colorado Rules of Evidence 401 and 402, not hearsay under 801, and certainly a hearsay exception under Colorado Rule of Evidence 803, and his right to present a defense under both the United States and Colorado Constitutions.
All right, thank you. Who wants to respond?
I do.
Your Honor, it's immaterial whether they use this in their opening. We're not required to give an evidentiary objection to everything that someone uses in the opening. They still have to get it admitted during the case in chief. I mean, we gave them notice of everything we were going to use in opening, and they didn't object to them then, but they've lodged plenty of objections to that same evidence that's been offered during trial. So, and they had advance notice of all of that. So that, to me, is immaterial as to whether or not they can lay a proper foundation to admit any of this. Ms. Higgs seems to forget that what we entered of the defendant's statements is a well-established hearsay exception of admitting defendant's statements by a party opponent. They are not a party opponent, so they do not have the advantage of that hearsay exception. They went and did an interview with the defendant that they want to admit without him being subject to cross-examination on any of those statements. And it certainly seems as though they're offering all of those statements for the truth of the matter asserted. This is simply not admissible under any of the hearsay exceptions, and I don't believe that it's admissible under 803.3 because a lot of this has nothing to do with his medical condition. They just want to get in a long interview of the defendant where we can't cross-examine the defendant on any of those statements, and that is not the same as us offering it as a party opponent, and they're offering it for the truth, and there's a lot of extraneous information in there about all of these. So the PD investigators are not his doctors, they are not treating him, so they don't need to establish his state of mind for the purpose of diagnosis and treatment. So I don't see how this is admissible in any way, shape, or form. If they want to show a video without any audio, I think they could do that, but I don't see how they are able to use the audio, and we absolutely would object to anything where they've added text to it as well.
All right, thank you. Well, I think that at least some of the statements in this, I think it's a 25-minute video, about a 25-minute video, so it's a lengthy video. At least some of the statements are being admitted for their truth. For example, statements about shadows, those are being admitted for the truth of the content. In other words, the defense wants to show that the defendant was talking about shadows, about seeing shadows under the blankets the night before. I understand that they want to rely on that to then argue about his mental illness, but they are being offered for the truth. So at least some of the statements in this interview are being offered for the truth of the matter asserted, and they are hearsay. At least, and then Ms. Higgs argued that one exception under the hearsay rule applies. The exception that she mentioned was state of mind. It's possible that there are statements in here that would fall within the state of mind exception, but certainly there are a bunch of statements in here that do not fall within the state of mind exception, 803.3. So that exception doesn't save the entire interview by any means. And I think Ms. Higgs at the end just mentioned 803 in general. I don't know what other exception the defense is relying on. The one they mentioned was state of mind, but I can't think of any exceptions under the hearsay rule that would allow the entire interview to be introduced. And this is about a 25-minute interview by an investigator of the public defender's office of the defendant while the defendant is in a hospital bed at Denver Health Medical Center in November of 2012. And it has sound. Generally speaking, you can understand what's being said. Every once in a while, there are things that are hard to understand, but clearly it's on audio. It's not just video without sound. It has sound, and you can hear not only the questions from the investigator, who's not a doctor, not a medical person, not a psychiatrist, and you can hear the answers the defendant is giving. It is interesting because in this case we've had a lot of expert testimony, and the experts have relied on a lot of this material. And so a lot of this information has been alluded to already through the experts. And I don't know whether Dr. Gurr will testify about relying on this and whether this will be admissible under Rule 703. And if the defense wants to attempt to establish foundation through her under Rule 703, they can try that. But I think given the record before me, I agree with the people that this is hearsay. And I understand the arguments Ms. Hicks is making in terms of what evidence the people have introduced. But the people have had to comply with the rules of evidence on every single evidentiary item that they have introduced. And that's because the rules apply. And there have been objections, and I've been ruling on the objections. I would not agree that there has been an open door policy that has allowed the people to introduce whatever they want. That there have been some things that I have not allowed them to introduce, and so they haven't introduced everything they've attempted to introduce. They've introduced what I have allowed based on the rules of evidence, or what the defense has not objected to, what the defense has decided that they don't want to object to, and they have strategic reasons for that. But certainly this particular interview contains hearsay, and and the hearsay exceptions, or the exceptions to the hearsay rule, do not apply to the to all the statements in the video. So the hearsay objection to the video is sustained. As I said, though, if the defense wants to establish foundation under Rule 703 or attempt to establish foundation, then they can attempt to do that. And I assume that this was sent to both Drs. Reed and Dr. Metzner, but maybe I shouldn't assume that. Were these videos sent to both of those doctors?
Yes, Your Honor, they were.
And, both doctors, I think, testified about the defendant's mental state around November 2012, presumably in part based on this video, and presumably in part on all the other records surrounding the November of 2012 incident. And so in a way, some of this has come out already, and the jury has heard about some of this, and presumably Dr. Gurr has relied on it too, but there's a certain foundation that you have to establish under Rule 703 for this to be admitted through that rule. So the defense can attempt to do that when Dr. Gurr testifies, or when any other expert testifies for that matter. Dr. Gurr comes to mind because she's the one that I would think may have relied on this, justifiably relied on this, and I'm not making any findings, I'm just saying it's possible, but if the defense lays the proper foundation under Rule 703, then I will readdress the issue at that point. Of course, the people will be allowed to respond to any request at that time as well, and we'll go from there, all right? So, Ms. Hicks, you may approach to retrieve the 2 discs.
Thank you. And the transcript?
Oh, and the transcript as well. Thank you. Thank you, and thank you for providing the transcript. I appreciate that. I agree with Ms. Pearson on the opening statement, part of the argument that the parties have made, that just because the people did not object to part of this being played during openings doesn't mean that they are not bound to that decision and they cannot object at this time. I think in opening statements, the parties are presumed to proceed in good faith, and I don't think an opponent can just object and say, I'm going to object to that without knowing whether the proponent is going to be able to introduce it into evidence to lay the proper foundation. For example, it's possible that these statements can be introduced if the defendant testifies. It's possible that in that case that perhaps it might be a different story. I don't know. It's possible that it might come in through Rule 703. There are all kinds of different scenarios, and I don't think that just because the people did not object in opening statements that, or an opening statement that they now cannot object. All right, Ms. Hicks?
Yes, Your Honor, we would ask to mark these as court exhibits. Do we know what number we are on?
What number are we? 78? So you can mark them on 78 and 79.
I'm going to, just for the record, mark the video with text as 78. the video without text as 79 and the transcript as 80.
Okay,
And I will give those to the court later.
Great.
Thank you.
All right, are the parties ready for the jury?
Yeah, Your Honor.
Sorry. Hey, Your Honor, I wanted to follow up on this issue that was raised by Ms. Wheeler from the Attorney General's office. We did reach out to her yesterday a couple different times. Tish, have we heard back? We have not yet heard back from her. However, we've gotten an email that was sent to me from Ms. Nelson to Ms. Wheeler indicating their objection to any use of the raw data, the answers to questions, or anything else other than just whatever the psychologist feels comfortable testifying to, and said that, I think in the email, and ma'am, if I'm misstating this, Ms. Nelson, you fix it. The gist of it was, hey, if Mr. Brockler's going to get into any individual questions, we're going to seek to publish the entire examination and all of its questions. I think that even without hearing from Ms. Wheeler, Judge, I think it's likely at this point that we're not going to reach some sort of consensus, and maybe it's appropriate to try to schedule a hearing in advance of those witnesses for the court to address that. I know from speaking with Mr. King this morning that he anticipates that Drs. Gray and Manguso, who are most likely the ones that would testify about these tests, specifically Dr. Gray, that they'll be testifying tomorrow at some point. And I know that creates a bit of an urgency issue, but it's where we find ourselves, Judge.
Well, it's whenever Ms. Wheeler is available. I'm here and you're here and they're here. The defense is here, but it's whenever Ms. Wheeler can get here. I'm happy to have a hearing, a short hearing about what the concerns are and what we can do. I mean, I'm sensitive to the concerns about copyrighted material, but I'm also sensitive to making sure the parties are given an opportunity to try their case. And so it's a difficult thing. I mean, something's going to have to give, and that's why I was hoping that Ms. Wheeler could work with the parties to see whether there was some kind of agreement that could be reached that would allow you, Mr. Brockler, to inquire into the data underlying the test without perhaps jeopardizing some of the copyrighted material in the test.
Your Honor, I just got handed a note from Ms. Tish McGuire indicating that Ms. Wheeler just reached out to us and indicated she would talk with us today. Maybe we table this for the moment. We'll work with her on a resolution or a date that she can be available, a time that she can be available.
Okay. Mr. King?
And Judge, just for clarification, I think part of this turns on how this data is used and to what extent. And that's the reason that Ms. Nelson sent the email that she sent this morning after we got a chance to consider it. And just to give the court an inkling of what I'm talking about, there's a real difference between asking questions about the psychologist's interpretation of the data. For example, you overemphasize the K scale, or you misinterpreted or miscalculated the correct result from the testing that was given. That's a very different thing from going into the questions of the tests themselves and taking them out of context and inferring meaning from the individual questions, which is completely improper use of the material, and that is what would also jeopardize the copyright, because that's the actual test itself.
And so you're saying that if Mr. Brockler gets into some of the questions, then you're going to, at that point, be in a position where you think you'll want to introduce the entire test.
The MMPI, for example, Judge, is 567 true-false questions. It's many scales that are interrelated statistically, and the validity of the test comes from the statistical validation of the test taken all together as an entirety. If you take one question out, and many of the questions are extremely odd, for example, and if you take one of the questions out and attempt to infer meaning from the answer to that question, it's very misleading. and not reliable under any standard of admissibility under any court that I'm aware of. So that's kind of the distinction that we see here. And I'm not speaking for Ms. Wheeler, obviously. She may have different concerns, but that's the concern we have. And the court is right. If the court were to allow Mr. Brockler to go in and individually select out the questions that he happens to like the answers to and present them to the jury out of context, it's very misleading to the jury, and it would put us in a position where we have to then go in and select the questions that we want and present those to the jury, and it becomes a misuse of the instrument, Judge. And so that's where I'm coming from at this point. And so in terms of when Dr. Gray is going to testify, I told Mr. Brockler this yesterday. When I told the court yesterday that he was scheduled for Thursday, I meant Wednesday. And that was because of the short week. I got confused. But I stand by what I said yesterday, that if we need to delay his testimony to resolve this issue, we can certainly do that, I think, given his schedule. So.
Okay, thank you. Mr. Brockler, at this time, you think you're going to get into some of the questions and answers of the test? Is that the data that you are referring to?
It is, Your Honor. And I would say, unless the court has another question, I mean, in part here what we're suggesting through this argument is that the experts get to tell us how we value true-false responses to factual questions. I'll give the court one example. This MMPI 2 report is generated by computer software. This psychologist will say, I don't go in and add any language to it. It just prints out based on these answers. And one of the things it'll say in that report is that Mr. Holmes feels hopeless. Well, as it turns out, there's an actual question in there. True, false. The future seems hopeless to me. And he answered, false. Why shouldn't the jury be allowed to consider those kinds of discrepancies when it is a software package that determines the language of the actual report that's generated, and then psychologists interpret them? Now, Mr. King can certainly ask the psychologist to tell the jury, hey, it's not fair for you to consider true-false questions individually about factual things. But that's for them to decide. Psychologists don't get to come in here and tell us what the jury should be permitted to. You do, Judge, and they get to weigh those things. That's great stuff for direct or redirect, but it doesn't seem like it's the gatekeeper for a true-false question about a fact.
Is there a way to accomplish your goal without getting into the specific question? So, for example, I am assuming the jury is going to hear that one of the conclusions was that Mr. Holmes feels the future is hopeless. Is that what you're expecting?
That's what the report says, Your Honor, and I presume the psychologist will testify about that.
All right, and can you then ask, isn't it true that there was a specific question asked about this topic, and that contradicts that conclusion? I mean, can you ask that without getting into the specific question?
I think I could ask that, Judge, but I think based on some of the other questions that are here, the word contradicts is a conclusion that they may disagree with. They may say, well, I don't think it contradicts it. I think because of this word, that question should be interpreted a different way, or in and of itself it shouldn't matter. And the issue is, should these folks be able to hear that he answered false, the future seems hopeless to me, when the conclusions of the software and the psychologist are, oh yeah, heavily depressed, he thinks the future is hopeless. And there's a number of examples like this in a bunch of different areas. I could go general. My concern is we're going to get there and the doctor is going to say, I don't agree that that answer is inconsistent.
And have you talked to Drs. Rose and Manguso about this?
Dr. Manguso, I'm hopeful of talking to her before she takes the stand tomorrow, Your Honor. We're trying to effort that.
Okay.
Well,
Mr.
Judge, Dr. Manguso didn't get administered these instruments, so I don't expect that she would testify about them. Dr. Gray,
I meant.
Dr. Gray is the person that administered these instruments. I have discussed this with him, and he indicated this would be a misuse, a gross misuse of these tests. And the example that counsel is giving of the juror being able to interpret the answer to a specific question is exactly the problem. That is exactly what is an improper misuse of this testing data, and it's very dangerous and very misleading, and that's what psychologists would testify to. So I think I wanted to give the court an idea of where I was coming from. I think we may be getting a little ahead of ourselves here.
Right.
And we would ask for a hearing before any of this was actually admitted and a chance to present evidence.
All right, I think I said Dr. Rose and Manguso. I meant Dr. Gray and Dr. Manguso. But let's see if Ms. Wheeler can come here, and I think it would be helpful to have Dr. Gray present as well, because he may shed some lights on some light on this.
Understood, Your Honor.
So,
We'll work with Ms. Wheeler. I presume Dr. Gray, being the defense's witness, they probably have a pipeline to him to get him here.
well, he can be here if he can be here today, this afternoon, at the end of the day, then, we can take it up at the end of the day today. If not, we'll do it tomorrow. But it would probably be helpful to have him present while we're discussing this particular issue.
Yes, Your Honor.
Okay. All right, by the way, before I bring the jury in, with respect to Exhibit C-TR-78 and C-TR-79, I just want to make clear that my ruling was based on the exhibit that was submitted to the court. In other words, the interview in its entirety. I'm not ruling on any redacted or edited version of it without sound, or any redacted or edited version that would cut out some statements. It was tendered to me, and I was informed the defense wished to introduce the interview in its entirety. In its entirety, my ruling is it contains hearsay and at least portions of it, and therefore it cannot be admitted. All right, are the parties ready for the jury at this time? The people?
Yes, Your Honor.
The defense? Ms. Nelson?
Your Honor, I have two brief instructional issues that I wanted to discuss with the court.
Yes.
The first was just the court made some comments yesterday about the potential inconsistencies of when we've requested the limiting instruction be given about the jury's consideration of certain evidence solely for the purposes of sanity.
Right.
I just wanted to give the court, I gave it some thought last night, and I just wanted to let the court know where we're coming from and what our position is on the limiting instruction, just so that we're all on the same page. I went back and looked at motion D-276, which is the motion in which we requested that the court give this limiting instruction. And really the basis and the origin for that limiting instruction is section 16.8.107.1.5a, which talks about the limited purpose for which information, including communications derived from a court-ordered examination, as well as communications derived from the waiver provision of 103.6, the limitations placed on those, that information. And the purpose, obviously, behind that is to protect a defendant's right to self-incrimination. And so that's the reason in the statute that there's a specific legal reason why that evidence derived from those two statutory provisions can only be admitted as to sanity and not as to any other purpose, such as the defendant's guilt. It's to protect the defendant's Fifth Amendment right. So in our view, I think the limiting instruction applies obviously to anything that comes out or came out about Dr. Reed's examination, Dr. Metzner's examination, which the court instructed the jury properly, as well as, pardon me?
The notebook.
The notebook, and then medical information that was disclosed as a result of the waiver provision of 103.6, so testimony from medical doctors who examined him, our experts, etc. So all of those situations are appropriate. All that testimony is appropriate. The limiting instruction is necessary and appropriate. And I think, if I'm recalling correctly, that the court inquired whether we wanted the limiting instruction to be given with respect to some of the testimony coming from the jail deputies, if I'm remembering correctly. And I think that's different because there's no legal reason to restrict the jury's consideration of that evidence. Now, it may be that the jury doesn't think that evidence is relevant except to the issue of sanity. However, I don't think it's appropriate to give the jury that particular limiting instruction, because there's nothing in the statute, there's no legal restriction on the jury's consideration of that evidence. And in fact, as we had a discussion during the charging conference last week, perhaps they want to consider it as part of a Hendershot Van Rees type defense of whether in fact he did form the culpable mental state, not whether he was capable of forming the culpable mental state under Part B insanity. So that's our position as to when the limiting instruction is appropriate to be, or should be given, and when it should not be given. Does that make sense?
Yeah, it makes sense, and I agree with you in terms of the legal basis for the instruction. And I think I've given it pursuant to the law in the circumstances that you've mentioned. I've given it in a couple of other cases or a few other circumstances at your request or at the people's request without your objection. So, from here on out, if either side wants me to give the instruction, then it's going to be on you to ask for it. And I'm going to put it aside and not give it and not ask you about it. And I'll only give it if either party thinks I should give it. And if there's a disagreement, then I'll resolve that disagreement here at the bench. Does that make sense?
Yes.
But so far, I've given it when either both sides have asked for it or when one side has asked for it without the objection of the other side. And so it's been given generally, I think, as Ms. Nelson indicated, when Dr. Reed testified, when Dr. Metzner testified, with respect to the notebook, it was given. It was also given with respect to Dr. Fenton, with respect to Dr. Feinstein, and then in a few other occasions that either the defense has asked me to give it in, or with respect to, or the people have asked me to give it with respect to without objection from the defense. So, but I appreciate you reacting to the what I was wondering about yesterday, and it makes sense, and so we'll just do it that way, okay?
Thank you, Your Honor.
So the parties are both on notice. That's how we will proceed. What about the proposed instruction based on Mr. King's request?
Yes, that was my second item. I made some, I would like to suggest just a couple of modifications to the court's proposed instruction.
Yes.
We're fine with the first paragraph. Our proposal would be to omit the first sentence of the second paragraph, and I can tell the court, my only concern is just conveying to the jurors that there may be a fine line in terms of what they can use and what they can't use. I think the instructions to the jurors should be, while there may be a fine line, legally speaking, and a fine line for the lawyers in the court to sort out, in terms of conveying that to the jury, that might just confuse them in terms of, well, when can I and when can't I? So my proposal would be to omit that first sentence of the second paragraph. And then the other proposal, and this is also taken directly from the Kendrick versus Pippin case that the court relied on as well. I just wanted to add something to the last sentence of the second paragraph, stating, while a juror may use, so the addition would be, and I typed out a revised copy of this that might be easier for me to just submit it in writing to the court. But I can tell you that I'd like to add, while a juror may use her personal experience or knowledge where that knowledge is relevant to the matter at hand, a juror may not introduce extra facts or law from an outside source that are not part of the evidence in the trial. Or I guess it would be that is not part of evidence in the trial. Would the court like a written copy of my revisions?
No, that's okay. Okay, I agree with your suggestion with respect to the second paragraph and specifically the first sentence. I didn't like that sentence anyway, so I completely agree with you. And I don't have a problem with your last sentence. It's frankly a little repetitive in my view, and I don't know that it's necessary, but I don't have a problem with it. Do the people have a position?
I was about to say it's somewhat repetitive, but
Well, now you're being somewhat repetitive.
Yeah. Well, that's probably the correct assessment, Your Honor. I think it would actually read less repetitive and more clear if we just got rid of that first sentence in the second paragraph, because I don't think that the additional language proposed by counsel really adds anything that isn't there already. So that, I don't have an objection. In fact, I think it's a good idea to get rid of that first sentence in the second paragraph, but I think once that's done, the instruction's fine as it is.
How about this, Your Honor? What if we just added to the first sentence, jurors are allowed to use their background, including their professional and educational experiences, when that background is relevant to the matter at hand to inform their deliberations? Or just, that's the only part that proposal that I made in the last sentence adds, is just, when it's relevant to the matter. That's really all I care about. Sort of states the obvious, but I think it's better to have that in there.
But you still want to inform their deliberations?
Yes.
Okay. So it would read, jurors are allowed to use their background, including their professional and educational experiences, when that background is relevant to the matter at hand, to inform their deliberations, so long as they do not bring in specific factual information learned from an outside source. I'm not crazy about when that background is relevant to the matter at hand to inform their deliberations.
Your Honor, if I may?
Yeah.
I agree with what Your Honor just said. To me, that is going to impose a very confusing limitation on the jurors' ability to use their background and experience and so forth. We tell jurors to use their life experience and their common sense when they come in, and we don't explain to them there are certain parts of your background, life experience, that you can use and certain that you can't. It can be all kinds of things that inform a person's understanding of the world and common sense that can be used in their analysis as a juror. And to try to put a limitation on that by having them sort of act as a judge and make a 403 analysis as to whether it's relevant or a 401 analysis, and without even really telling them what relevance means and how they're supposed to make that decision, I think could be very confusing.
Well,
And Your Honor, it's lifted directly from that Kendrick case, but I understand what Mr. Orman's saying. I leave it to the court's discretion.
I just don't like that phrase. I don't like the word relevant in there. I don't like the matter at hand. Matter at hand are things that lawyers use, but not necessarily lay people. That's not how regular, normal people speak. So I think I'm just going to leave it the way it is in terms of the first sentence, Ms. Nelson, but I will, that's the first sentence of the whole instruction, but I will take out the first sentence of the second paragraph the way you've asked me to do. And I don't think the last sentence adds anything, and so I'm not going to add that sentence. But I'm happy to give the instruction. Do you want me to give it today, or, and do you want me to tell them why I'm giving the instruction? In other words, do you prefer that I say something like, members of the jury, a couple of you have submitted questions that reveal that you have some medical background, or you may have medical background. Let me give you an instruction at this time, or do you want me to just give the instruction?
I think just give the instruction, Your Honor, and yes, I think we'd like it today.
Okay. Any objection from the people to me giving it today?
I don't object to that, Your Honor.
All right, I'll give it this morning when they come in, when the jury comes in. All right, are we ready for the jury now? Yes? Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is in the courtroom now. Good morning, everyone. How's everyone doing? Everybody doing okay? Great. Thank you for your patience with us this morning. As you know, there are times when the lawyers and I have to talk about legal issues or administrative issues or scheduling issues or perhaps more than one of the above, and we have to do that outside your presence. But I very much appreciate your indulgence. Before we start this morning, I have an instruction that I'm going to give you. It reads as follows. Jurors are allowed to use their background, including their professional and educational experiences, to inform their deliberations so long as they do not bring in specific factual information learned from an outside source. Any experience used by a juror in deliberations must be a part of the juror's background, gained before the juror was selected to participate in the trial and not as a result of an independent investigation conducted after being selected as a juror. Additionally, a juror may not introduce specific facts from an outside source that are not part of the evidence in the trial. Does everyone understand that? And everyone's saying yes and nodding their head yes. And I gave some of you a similar instruction, a few of you, during individual jury selection, if I remember correctly. But some of you may not have heard it, and the instruction that I gave earlier may not have been as complete as the one that I just gave, okay? All right, with that, we'll proceed. Would the defense please call its next witness?
Your Honor, the defense would call Sandra Pagan.
Good morning. Could I have you raise your right hand for me, please? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, please be seated. Please tell us your full name and spell your first, middle, and last names.
Sandra K. Pagan, Sandrakay, Paggen.
Can you move the microphone closer to you, please? You're soft-spoken, and we want to make sure that we can all hear you, okay? All right, Mr. King, you may proceed.
Thank you, Your Honor. And thank you, Ms. Pagan, for coming in. You've been very patient with us. The microphone will actually slide right closer to you if you pull it.
Oh.
There you go. Can you please tell us, are you employed now or not?
No, I'm retired now.
Okay. And what did you do before you retired?
I was working at Arapahoe County Jail as a day nurse,
Okay.
RN physician in the infirmary.
And did you just say you were an RN?
RN.
Okay. And what were your responsibilities, just generally speaking, as a nurse who worked in the detention facility here?
My primary one in the infirmary was taking care of and monitoring the inmates that were in the specialty units.
Okay.
Medication.
Giving them their meds and checking on them to see whether they were doing all right?
Mm-hmm.
And
Yes.
I imagine that can be a busy job, fair to say?
Yes.
Were you working there during November of 2012 in that capacity?
Yes, I was.
And do you recognize Mr. Holmes, who's seated over here?
Yes.
And was he housed in that unit at that point in time?
Yes, he was.
When you spoke with Mr. Holmes, well, first of all, did you speak with Mr. Holmes at times, just in
Yes.
passing? And what was your interaction with him? Did he talk back to you?
Yes, oftentimes he would just simply say, "I'm fine."
Okay.
Ma'am, I'm sorry, you're soft-spoken.
Oh,
Can you move the microphone closer to you?
Yes.
Just the microphone moves, so you can move it.
I thought,
Just move the whole thing. There you
Okay.
go. Thank you.
what I'd like to do, did there come a time when there was a change in behaviors that you noticed Mr. Holmes engaging in somewhere around November of 2012?
The middle of November.
Okay. And I've got here a copy of the notes from the medical facility in the jail, including your notes, if I can approach Judge just in case she needs to refresh her recollection with this.
Yes.
And I don't know if you've had a chance to review any of those before your testimony here today, ma'am, but if you need to, you can feel free to take a look at that. I put a little blue sticky on around the 11th or 12th of November there. Well, first of all, those notes that you're looking at, what's the purpose of taking notes like that?
We documented every day during our shift, general behavior, any, changing of behavior,
Okay.
and to make sure that it was documented that he had done what we called activities daily living, that he was up, showered, took care of himself, had a meal.
And is that part of your responsibilities in taking
Yes.
care of these folks? And I assume you would do the same for anyone else who was in there.
Everybody.
I want to first take a look at, if we could, your note from November 11th. Was that about when things changed a little bit?
Yes.
Tell us generally what happened. What took place that caught your attention, or did you notice about Mr. Holmes during this period of time?
What I would say is his activity became a little more physical. He was, usually he just laid in bed and rested, and he would get up and exercise at times, but it just seemed he was exercising on getting up and doing push-ups and jumping jacks and exercising. Just being a little more active.
Okay. And do you see the note there from November 11th at 12:22?
Yes.
Was he moved to a suicide room or cell on that date?
I think he's still in medical on this date, on the medical side.
Okay. Was he given a suicide mat then, that date?
Looks like he was. Looks like the deputies gave him a suicide mat.
Okay. What does that mean?
That means that he's being protected so he doesn't hurt himself.
Okay. Did he have anything else on at that point in time other than that suicide map? Can you see in that note there?
Yeah. Looks like he's been moved in the evening to BC5, which is a behavioral unit.
Oh, and
And when
that's
they go in the BC side, that means they have to have a suicide mat to sit on the floor. If they don't have one, then we try and get them one.
okay. And other than that, would the person have any other clothing or not?
They are given clothing.
Okay.
Sometimes they don't keep it on, or they're not given clothing. I think he was given some clothing, and he sat on his clothing.
Okay. Do you see there in that note whether or not Mr. Holmes ate any food, ate at breakfast or lunch that day?
According to this, he ate the breakfast, but the lunch sack was still there at
Okay.
the end of the day when I charted.
Great. Thank you. If you could now take a look at the next day, which is November 12th, and I think your note is at 10:33 in the morning.
Yes.
Now, did he come to the door to get breakfast, the door of the cell to get breakfast that morning at 10:33?
No.
What did you observe him to do at that point?
He was laying like in a frozen position on the floor, on his stomach.
Okay. Can
And
you
he-
describe a little bit more what that looked like?
On his stomach with his arms twisted up like this, and his feet and his legs with his legs bent up in the air, just kind of,
Okay.
his legs up,
So he's
His
laying on his
arms-
back or his stomach?
stomach.
laying on his stomach and his arms are twisted out behind him like I'm
behind
doing
him.
right now?
And his legs up, kind of, and he was like frozen. He wouldn't move. Tried to move him, and he was stuck.
Okay, he was stuck. Did you observe what he did with the suicide sack breakfast that he was given?
Yes, he was in this position and turned face, and he was trying to like reach for or motioning towards the sack with his mouth, like he was like trying to reach for it to get it, but he couldn't reach it. It was just really odd watching it.
Okay. And was he naked at that point, or?
I'm thinking he's naked, yes.
What other behaviors did you notice that he was doing there?
On the video, we watched him take the, because we're watching him.
Okay.
He's not, acting okay. And that he gets unstuck, but he sticks the sack and he puts it down the grate. There's a grate in the middle of the floor
Okay.
that's used for toileting and garbage.
So he put the sack down the grate? What else did you see him doing during that period of time around mid-morning on the 12th of November?
Okay, we watched him on the video licking the walls.
Okay.
And then he would get up and just keep constantly rearranging his clothing on the floor. Just restless behavior. That's what I described it as. He just looked restless.
And did you try to communicate with him that day? Was he able, or did he communicate back to you when you tried to talk to him?
No, he did not. I mean, I tried to communicate, but he wouldn't answer.
All right. I think the next note is on the same day, November 12th, 2012 at 13:25. Would that be 1:25 p.m.?
Yes.
And again, is there any indication about whether he is able or willing to communicate with you at that point?
He's not able to communicate.
What do you mean by odd eye contact? Do you remember?
Yeah,
It was a long time ago.
yeah, just a blank stare, like he'd just look at you and be looking right through you. Just no connection,
As if you weren't there? Or?
as if it wasn't there. Yeah, he'd just be looking straight. But no, he would look, but it was
Okay. And
connection look.
are you demonstrating that look
Yes.
for us? Does your note from 1:25 that day indicate whether he continued to do odd behaviors that afternoon?
Yes, he did. When it was lunchtime, I was there when he was, he took two of his paper cups. He always had two paper cups sitting of water
Okay.
on the little, by the door, and he had crushed those and took the bread, tossed the bread, and he put the sandwich meat between the bread and ate it.
Put the sandwich meat between the bread or between the
Put
cups?
the sandwich meat between the two cups and was attempting and chewing on the cups
Okay.
and the meat.
And the paper too?
Yes, the paper cup.
And there's a note there about a trick that he did or something? What was that?
He had another cup that he, was flattened,
Yes, ma'am.
and he tossed it through the grate where the slot where you have the food coming in.
Yes, ma'am.
He tossed it through there.
Okay.
Yeah.
What does it mean when in your note says, did backward somersaults with a cup balanced on his penis during the trick?
Yes, that trick. Many times he tried to do a backward flip with a penis delicately, precisely placed over his penis area, and then try and jump backwards and see if he could keep it in place. He did not succeed, but he tried several times.
Was this behavior, how long had you worked in the jail?
12 years.
Was this odd to you to see this kind of behavior?
It's odd behavior. I've seen very odd behavior.
Okay. You've seen other people that have
Much.
demonstrate odd behaviors?
Definitely,
Did
yes.
some of those people have mental illnesses?
Yes.
The next note, I think, is on the next day, November 13th, and it's at 10:01 a.m., I believe. Is that right?
That's when I started the chart, yes.
Okay. Is there a note there about him being moved from that one cell BC5 into another cell BC4 on the blanket, moved on the blanket?
Yes, I was there with him when they moved him.
Okay. Why did they move him? Do you recall?
The room was not fit to live in. It was full of feces, and he was too.
Okay.
So we moved him out of that room into a clean room.
And do you know whether or not whether there's video cameras in these rooms that are recording at least some of this?
It should have been recorded at all times.
It should have been recording at
Yes.
all times? Now, at this point in time, if you look at that note from 10:01 a.m. on the 13th of November 2012, was Mr. Holmes able to stand up at that point, do you know?
He was not.
What was he like? Was he, when they tried to move him from that one cell to the other, how did he respond to that?
He was in another frozen position, unable to move, stand up. He was in a very tight frozen position, so we just put him on a blanket and they
Okay.
moved him across the hall.
Okay. At some point that day, did you notice him, like, flailing around on the floor, like naked on the floor, kind of flailing around, or?
He wasn't, I can't say he was flailing.
Okay.
He didn't respond, I went to do a welfare check on him when we got him into the new cell.
And is that one of the things that you regularly do when someone's moved into one of those cells?
We check on them, especially because if they're acting, whether it's disciplinary or his was for medical reasons, because he wasn't, acting like he was well.
Okay. And so that welfare check, do you just go in and try to communicate with them and see how they're doing?
See if they're oriented, communicate, find out what's going on, what we can do.
Okay.
And he was not cooperative.
Was he able to respond to that?
No. I asked him what was going on, and he just mouthed. I couldn't even figure out what he was mouthing. He was just mouthing.
Like mouthing words?
Mouthing, looked like mouthing words.
Did any words come out?
None.
What did that seem like when he was doing that? Did it seem like he was trying to talk, or could you tell, or?
It looked like he was trying to talk, but nothing came out.
There's a note there about sclera.
Eyes, I wanted to check his eyes, because he'd had a head injury,
Okay.
and he had a bump on his head, and I wanted to check his eyes and see how he was doing and see what his pupils were doing. And he resisted, so I opened them, and they were very bloodshot and very full of, looked like to me tearful, wet.
Tearful?
Very wet.
At some point that day, did you attempt to get a blood pressure on him, and deputies had to kind of restrain him?
He wouldn't let me do a blood pressure. He tightened up really, really tight. He was already in a tense position, but he would not cooperate with me to get a blood pressure cuff on.
Okay.
The same way with his eyes. He had his eyes squished shut, so I had to open them to take a look at his pupils.
You had to open them with your fingers to open his eyes?
Mm-hmm. Yes.
What else do you note in there? Was he having a problem with feces again in that cell as well?
Not while I was in there.
Okay. What else does it say in that note that you noticed that day?
What concerned me was the fact that he had the bump on the head. He was not responding. He was acting, and I wanted to rule out and make sure he didn't have like a concussion or hurt his neck.
Did you have a doctor come take a look at him then, that morning?
Dr. Grope.
Okay. And is that Dr. Jason Grope?
Yes.
Was he one of the doctors that worked at the jail at that point?
Yes, he was.
And did he come by around 9:30 to make an assessment of Mr. Holmes that morning?
I know he came in and took a look. I don't know if it was 9 o'clock.
Okay. It's been a long time, right?
No, I don't have my glasses on, so I'm trying to read this.
You can borrow mine if you want. And Dr. Grope, is he a psychiatrist or is he a medical doctor?
Medical doctor.
Okay. Do you recall whether at that point in time Dr. Grope gave Mr. Holmes an IV?
No, when he was, I understood he got the ID when he was in the ambulance, when the ambulance people came.
Before the ambulance people came?
Yeah.
Okay. And so was that day that the ambulance came on the 13th? If you look at your note from the 13th of November 2012 at 11:34 a.m., does it indicate that that's when the ambulance came?
Right.
So was it before that Dr. Grope administered an IV?
I don't remember the IV other than the ambulance saying that they put an IV in him when they came back from
Okay.
bringing him back from the hospital.
Okay. And do you remember anything else about what he looked like or acted like when he was in the ambulance and they were getting ready to take him?
Well, when the ambulance got there, he was able to get up and get on the gurney,
Okay.
which surprised me. And then I followed him to the ambulance, and they put him up in the ambulance, and I took one last look at him, and he was like totally scared.
Okay.
Eyes were moving around like, what is going on here? And he was crying.
Okay. I think your next note is from the same day, the 13th of November 2012 at 13:51, which I think is 1:51 p.m.
Mm-hmm.
Was that the time about when he returned back from the hospital?
Right,
That same day?
that same day.
Do you know whether or not that's when he got that CAT scan, the first CAT scan?
Yes,
And was it then that they'd indicated that he did receive some IV fluid while he was in the...
that the ambulance driver, when they brought him back, said they had given him 500 cc's of IV fluid
Okay.
while on the way to the hospital.
Now, when he returned, was he all better, or was he in the same disposition as when he left?
Same disposition,
Was he still unable to really communicate?
unable to communicate.
Was he mumbling?
No,
Okay. Did you try to weigh him or assess him somehow?
they were looking for, just to make sure about comparing his weight to see if he lost a lot of weight, because he hadn't been eating or drinking for the last 48 hours, really.
Okay. Did it appear like he was aware of what was going on?
No, he was not.
And was that the last day until the 18th? Did you have some days off there?
I had
starting
days
that?
off, yes. That was it.
And was that really the last contact that you had with Mr. Holmes?
Yes.
Was that day?
That day.
Okay. May I have one moment, Your Honor?
Yes.
Thank you very much, ma'am. I have no other questions.
Thank you.
Cross-examination, Mr. Orman.
Thank you. So you've just been talking with Mr. King about, good morning, ma'am, about this incident that happened in mid-November, which was about 1 week short of 4 months since the shootings in the movie theater, right?
Yes.
I want to ask you first about this ambulance. You testified, I think, that he was sort of unresponsive on the floor. You couldn't do any medical checks on him. Wasn't moving around. He had stiff limbs. And you take him to the ambulance bay, and the ambulance arrives, and he sort of pops up and walks over to it, right?
In the cell, when the ambulance, they come to the Sally Port, then they came to his cell.
Okay.
And it was time to get up on the gurney, and
Yeah.
he got up and got on the gurney.
No
Walking
problem.
swiftly, but he got up and he actually helped them get himself onto the gurney.
So he stood up, yes?
Yes.
And then seemed to understand what the gurney was there for,
Yes.
and put himself in the gurney.
He assisted himself with the ambulance people to get up on the gurney.
Okay. And then a few hours later, Well, and did that seem to be different from what you had observed an hour before, around 10 o'clock?
I wasn't expecting him to get up. I thought we'd have to lift him up on the blanket.
So based on the way that he was previously behaving, you thought people would have to, that he would be totally unresponsive, wouldn't know what was going on, and actually have to be lifted up and put onto the gurney.
Yes,
But instead, he stood up on his own and put himself in the gurney or helped them do that.
yes.
Objection misconstrued the testimony. She said that with the assistance of the ambulance personnel, he got on the gurney.
The objection's overruled.
So that was a yes?
That was a yes.
I want to now go back in time, because you've talked about your observations of the defendant, I think throughout the time that you saw him at the jail, and specifically we're talking more about November. I'd like to go back in time to July. And would it be fair to say that that's sort of when you first met the defendant, when you first had an opportunity to see him in the jail?
Yes,
Now, the first note I have, and tell me if this is in fact the first time you would have seen him, would have been around July 29th. Does that make sense?
yes,
And fair to say that in July, when you saw him, he was responsive to you when you spoke to him
yes.
and would answer your questions,
Briefly, 1 or 2 words.
but still answer your
Still
questions.
answer.
If you said, "Yeah, how are you doing?" he wouldn't say, a basset hound. It was an appropriate response.
Yes,
So July 29th, 2012, in about 1:20, 1:21 in the afternoon, you saw him, and he was answering your questions with yes or no questions, right?
yes,
And he ate all of his lunch on July 29th, right?
I'm not looking at my notes, but I would, if I said yes, he's,
Okay, would it help to look at your notes for July 29th?
okay.
And for the record, the witness is looking at her notes.
Okay, July 29th at 13:21?
Right.
Okay,
So, so he answered your questions with yes or no comments, right?
yes,
Ate all of his lunch, right?
yes,
Rested on his bed, and he got up to use the toilet, correct?
yes,
Appropriately, right?
appropriately.
And because of the whole jail or something was on lockdown, he couldn't get out for his time out of his cell, right?
Yes,
But on other occasions, you did see him get out of his cell for what you call the time out from the cell.
yes,
Let's go to July 30th. At 7:58 in the morning, you have a note, and he ate all of his breakfast and shaved, correct?
yes,
And was cooperative.
yes,
A little later, the next day, in fact, July 31st, at around 1:35 in the afternoon, again, you had seen him that day, correct?
yes,
And he was compliant and cooperative on July 31st, right?
yes.
It says in your notes he completed ADLs. Can you explain what that means, ADL?
Activities of daily living, that means he got up and he took a shower, walked around, shaved, ate breakfast, did what he wanted to do,
In fact, he ate both of his meals that
ate both
day.
of his meals.
And he requested and got approval to have time out of his cell at that time. Is that what that says in there?
Yes,
I think I skipped a day. Let's go to July 30th, and specifically the morning. He ate all of his breakfast and shaved and was cooperative on that date, correct?
At 7 in the morning, yes.
Yeah.
8 o'clock, yes.
Now, on July 29th, you also had to do something with the defendant that you do for everybody that goes into the jail and do a TB test, correct?
Yes,
And that's for purposes of ensuring that nobody brings an infectious disease like tuberculosis into the jail. And on that date, you gave him the TB test, and he responded compliantly with brief eye contact when you did that.
yes,
And again, he ate most of his breakfast on that date, correct?
yes.
I want to go forward to another note that you have for some dates in August. And I want to start with August 15th on that date. On that date, you noted that he had contact lenses delivered to him. Is that right?
I'll sit down. What time are we looking at?
You know, it's a different type of note. Would it help you if I showed it to you?
It would, but I
Okay.
know he gets his contacts delivered.
Would it help to show you this note? And if I may approach, Your Honor.
You may.
Can I ask you a few questions up here, Your Honor?
That's fine.
Thank you.
If you would use a microphone, please.
So when he...
Oh, that's my pen. I was going to point to something there. If you can look at that bottom one right there, is that saying that he got his contact lenses delivered that day?
The case was provided.
Okay. The case, what does that mean?
What holds the contacts?
And then let's go to the 21st, and I don't know if you have a separate note of that, but you write in here how he says, how does this ABX work? What's it called? What's ABX?
Antibiotic.
So you were giving him some antibiotics?
An antibiotic for his finger.
For his finger. What had happened to his finger?
I don't know what happened to it, but it became infected, the nail bed.
So you gave him some antibiotics, and he asked you, how does the antibiotics work?
Yes.
Did he ask what the antibiotic was?
I want to know what it was and how did it work.
Then let's take a look at the note here for August 26 in this area where you say met his own ADLs. Again, that's he was doing his activities of daily life, right?
Yes.
No problems with that.
No problems.
Ate both of his meals. Is that right? Here, why don't you take a look at this?
Okay. Where am I at?
There.
Ate both of his meals.
And then let's take a look at the next one. Watch TV. Looks like up a little higher on this, we have a note about the Band-Aid or the cut on his finger from August 20th. And he said to you, I need another Band-Aid. The one you gave me broke open, right?
Yes.
On August 23rd, he took his meds, presumably the antibiotics, without difficulty, right?
Right.
You exchanged the Band-Aid, and there was no problem doing that, right?
None.
He ate all of his breakfast, correct?
Yes.
And at that point, he was allowed to have his commissary, right?
Yes.
And what's commissary?
It's food that they can buy
Okay.
and bring in for personal.
I have some notes here from September that I want to ask you about. Specifically starting with September 9th. And you have a note from 2:26 p.m. on that date. Ate both meals, showered, did not shave, no concerns expressed, correct?
Yes.
So he was essentially acting normally on that day
Yes.
in September.
In September.
Then we have a note from September 10th at 2:36. Do you have that?
2:36 p.m.
Yes, I'm looking at it.
And on that date, didn't have much activity, slept for most of your shift, refused breakfast but did eat his lunch.
Yes,
On September 11th, he ate both of the meals that you were there for on your shift, and he showered and watched television on his timeout, right?
yes,
And then occasionally would sit at the side of his bed and read.
yes.
Is there anything unusual about someone sitting on the side of their bed and reading at that part of the jail?
No,
And presumably reading a book?
yes,
Because the people in there can get books and
yes, they can.
Okay. Then let's go to September 16th, at, again, close to 1:57 p.m., around 2 o'clock. You observed him up early doing exercises that date, right?
Yes,
And he ate both of the meals that you were there for on your shift,
yes,
and he took a shower and shaved.
yes,
Fairly normal activities.
normal.
On September 18th, at about 12:35 p.m., you have a note. On that date, he was up at his bedside occasionally. You renewed his contact lens solution. He ate both of his meals, correct?
Yes,
And he was resting quietly, had not had his time out of his cell yet.
right.
Then September 19th, you were there again. He completed his morning activities of daily life, right?
Yes,
With no problem.
no problem.
He had a professional visit and returned without incident, correct?
Yes,
September 24th, you have a note, and the note for your, so you can take a look at it if you want to, is from 1:22 p.m. He ate both of the meals that you were there for, correct?
yes,
Again, had a professional visit and returned without incident, right? I'm sorry, I think
Yes.
we spoke over each
Oh,
other
I'm
for a
sorry.
second there. It's my fault, Again, he completed his activities of daily life with no problem and was showering,
yes,
correct? And he took his time out of his cell without any problems.
yes,
On September 25th at 2:30 p.m., you have a note where you observed him exercising in his room, correct?
yes,
And nothing unusual about an inmate there exercising in their room, correct?
correct.
And that's pretty normal, right?
Normal.
He showered and then returned to his room during his timeout, correct?
Yes,
Again, normal stuff.
yes.
I'm going to object to the continuing reference to normal.
Sustained.
Let's go to September 30th, 2012. You have a note there, it's for your reference date with 2:24 p.m. On that date, he ate the meals that you were there for, correct?
Yes,
He showered and watched TV,
yes,
correct? And appeared to rest for most of that shift, right?
yes,
On October 1st, you have a note for, so you can take a look at it, from 1:21 p.m. He watched TV on his timeout. You saw him do that, right?
yes.
And that was a typical activity for him?
Not as usual.
Okay, why is that?
His choice.
Okay. He took a quick shower, and again, no incidents noted, correct?
Right, correct.
Then the next date, October 2nd, for your convenience, your note is from 3:24 p.m. You observed that he spent most of your shift, resting and sitting at his bedside, but he completed a shower and returned to his room, correct?
Yes,
I think the next one I have is October 28th at 2:49 p.m. Do you have that one in front of you?
$249.
2:49 p.m., October 28th. You see that?
Yes, I do.
Okay. And on that date, you observed him doing his activities of daily life with no problem, correct?
Yes,
And you saw him exercise for 20 minutes or so, right?
yes,
And he showered, watched TV, ate both meals, right?
yes,
Then, at some point during that shift, you asked him how he was doing, and he said, "I'm good."
I'm good.
Now, he didn't make eye contact with you, but he said, "I'm good."
Yes,
A couple days later, in fact, the next day, October 29th, and for your convenience, your note is from 1:46 p.m. You saw him showering on his timeout, and he watched TV.
yes,
Then the next date, October 30th, and your note for your reference is 2:27 p.m. You saw on that date that he showered and he exercised, right?
yes,
And he read for a short time.
yes,
And he spoke briefly with the deputy about his exercising and said it was something for him to do.
yes.
The next one I have, and take a look if this will help refresh your memory, is October 22nd at 2:26 p.m. And tell me when you got there so you can take a look at it.
At 14:26?
I have, 2:26. Thank you. On that date, he took his time out of his cell, he showered and watched TV and ate both meals, right?
Yes,
And October 23rd, he had some type of professional visit, and he showered and watched TV on his timeout, and you didn't record any incident, right?
right.
Looks like I skipped a couple, so I'm sorry, I have to go back in time. So we have October 14th, and you have your note, I believe, is at 1:47 p.m.
Yes,
On that date, he was offered juice, and he said nope.
yes.
Was that a typical way for him to respond, nope? If you remember?
I've not heard nope very often. It's just usually no.
On that date, October 14th, he showered on his timeout, ate both meals, right?
Yes,
Again, no incident recorded,
yes,
at least by you. Then October 15th, and your note is from 2:23 p.m., showered and watched TV, spent a quiet day, and appeared to rest in his bed after a brief exercise period.
yes.
Again, no incident recorded.
No incidents.
And let me go back a couple more days. October 9th, and your note is from 2:59 p.m. I had some small talk with the deputy, right? The defendant did.
What time are we talking?
It's October 9th, 2012 at 2:59 p.m. is your note.
Yes,
And he showered and watched TV,
yes,
and again, you didn't record any incident,
Right.
correct?
yes,
October 7th, on that date, and your notes from 3:44 p.m., ate both of his meals, showered, sat up a while to read, and he didn't give any concerns.
right.
And again, no incident recorded.
No incidents.
I think I just got a couple left here. October 16th, and I think your note is from 3:10 PM. Tell me when you got there.
I haven't,
Again, no incident recorded that day, correct?
right,
And when asked, he voiced no concerns, correct?
right.
And October 21st, and your note, I think, is from 2:02 PM, and this is the last one I'm going to ask you about. Why don't you tell me when you got there?
I'm there,
On that date, again, no incident recorded, right?
right.
And he took a shower on his time out and went back to bed and ate both meals, right? Is that, yeah, is that a yes? And on that shift, he didn't watch TV?
Yes.
Okay. I don't have anything further. Thank you, Your Honor.
All right, is there any redirect?
No, Your Honor.
All right, the jury appears to have some questions for this witness. Give us a moment, please.
Yes.
Thank you. Would counsel please approach? Ma'am, the jury has submitted some questions that, based on the rules of evidence and other applicable rules of law, I have determined are appropriate. The first question is, from July 2012 to November 2012, did you ever give Mr. Holmes any medications?
Outside of the antibiotic, no.
The next question is, if yes, what were they? And you've answered that. And the follow-up question is, if no, do you know why? And I think you've answered that as well. The next question is, how did Mr. Holmes cut his finger that then became infected?
I don't think he cut his finger. It was like maybe biting his nail. It was really, really low, and it got infected.
The next question is, as a nurse in the jail, are you aware of the mental and physical status of the inmates that you're dealing with?
Yes.
Who controls or decides what medications are given to the inmates?
The doctors.
And how is that communicated to you?
If they want them on medication, we get a doctor's order to administer it.
Any follow-up questions based on those questions, Mr. King?
Well, Your Honor, with regard to the doctors prescribing medicines in the jail, would that include both medical doctors like Dr. Grope as well as a psychiatrist, Dr. Mosier?
Yes.
So if any of the inmates in the jail had psychiatric problems that required medication, it would be Dr. Mosier that would prescribe that medication?
Dr. Mosier.
And that was his responsibility?
That was his responsibility.
Thank you, ma'am.
Any follow-up questions from you, Mr. Orman?
And you don't know what limitations might have been placed on Dr. Mosier by someone refusing to speak to him, do you?
No.
All right, may this witness be released from our subpoena, Mr. King?
Yes, Your Honor.
Any objection?
No, Your Honor, thank you.
All right, ma'am, thank you.
Thank you.
All right, members of the jury, it's 10:25. Let's go ahead and take our morning break at this time. Let's take our usual 20 minutes. Please make sure you comply with all my admonishments during the break. Thank you. The record should reflect the jury has exited the courtroom. Everyone may be seated. Let's go ahead and take our morning break, and I'll see everyone back here in 20 minutes, all right? The court will be in recess. Thank you.